there should be this conversation around what your goals are and what's most important to you. And we also need to be looking. I'm a huge basketball fan. I grew up in Kentucky, so college basketball reigns supreme. I'm a huge University of Kentucky basketball fan, and I also love the NBA. And one of my favorite players, as is the case with many people, is Kobe Bryant, who passed away a few years ago. Tragically, he was in a helicopter crash with his daughter and several other people, and they all passed away. So there's been a lot of details around his estate that have come out since then that are very relevant and interesting talking pieces to consider. And so I recently read this article about Kobe Bryant's estate, approximately valued at $600 million, but there's some issues regarding adding beneficiaries, as I understand it, and this may have progressed further at this point, I don't know, but this particular article was talking about how they had set up a trust, I believe, before maybe his youngest daughter was born, and they had transferred assets to it, and maybe a big chunk of his estate had exists inside of this trust. However, his youngest daughter, if I have it correct, is not a beneficiary. So they're trying to figure out how they can move his daughter over to this trust as a beneficiary. And so every state is different when it comes to how you update a trust. So historically, when you set an irrevocable trust into place, and this is the kind of trust that is at question, and really it's the most valuable trust because it offers asset protection. It also allows for estate tax and generation skipping tax avoidance if done correctly. And so what they want to figure out is how do we change this irrevocable trust, because it doesn't accomplish what we need it to accomplish. And so there might be a variety of different reasons for that. Maybe you executed this trust and then you passed away and you didn't update it before you did pass away. And as I was saying, historically, you've not been able to update irrevocable trusts. You've not been able to amend them, or you just didn't really have flexibility to be able to revisit that trust. And in the last 20, 30 years or so, there's been this advent of really modernizing trust laws. And one of the most beautiful things is this role called trust protector. And so you can do a trust protector in any irrevocable trust. However, not all states have well-defined laws around the trust protector role. And so it might actually limit the ability of the trust protector to step in and perform its duties. And so the big power or authority that's reserved for the trust protector is for the trust protector to be able to step in and make amendments to the irrevocable trust. And one of those is the ability to add or remove beneficiaries. Okay, so even in certain states where you have the ability to have a trust protector as defined by law, there still might be laws that limit your ability to add a beneficiary or remove a beneficiary. And so that's one thing to consider. Kobe Bryant, when he passed away, was a resident of California. California is not known for having really flexible trust laws. In fact, I was listening to a podcast recently with, it was put out by a trust company and had an attorney in California who was talking, and he was talking about this idea of where to set up your trust. And he said, as an attorney in California who works with a lot of California residents, I almost suggest never setting up a trust in California. And Kobe Bryant's the exact reason why you don't want to do this. So if you don't have a trust protector, you have to seek some type of judicial reformation or modification of the trust. And you have to go before the court. You have to submit the trust to the court. You have to petition the court and tell them why you want to update this trust. And when you do that, everything in that trust becomes part of the public domain, or at least the details that you're discussing will become part of the public domain. So either way, you're revealing details that you likely don't want coming out. I mean, Kobe Bryant, let's be honest, he didn't want this coming out, but this is where they are now. And so they're seeking the California court to step in and give them the authority to make this this reformation or this modification to this trust. So why is this an issue? Because there's a better way. This is an issue because there's a better way to do this. And so this is the exact reason you want to look at the jurisdiction that might provide you the most flexibility. Who has the best laws around trust protector? And if that's not that big of a deal for you, maybe you live in a state that does have pretty good trust protector laws. But then you also need to look at two other things: the ability to add beneficiaries or decant, right? So you could take a trust that already exists, like this trust that Kobe Bryant set up, and you can move all of the assets over to another trust that perhaps names his youngest daughter as a beneficiary. So that's what decanting is, moving assets from one trust to another trust. And again, the law has to specify that the trust protector or someone in that trust has the ability to do that. California doesn't have real flexible laws around that. And the last thing is privacy. You need to consider privacy. So even if you were to go before a court, some states have rules around privacy when you present that trust or the information regarding the trust to the court. So Delaware has a law that says that any details that come out regarding a trust in a court proceeding would be, the judge has the ability to eliminate any of those details becoming part of public domain. He or she can put a seal on those details. But so they have the discretion to do that. So you're playing with, the judge making that call, and then the judge only has the ability to present the seal or to seal it for 3 years. So it's going to come out eventually, and people love this type of information. The other state that has a similar statute, but much, much better, is South Dakota. And so South Dakota says that any details that come out, there's an automatic seal. The judge doesn't even have discretion. They automatically seal any of the details regarding the trust, and there's a perpetual seal. It lasts indefinitely. It lasts forever. So there's no way that any of these details about Kobe Bryant's trust would have even come out if he would have done his trust planning in South Dakota. Now, I'm licensed in Pennsylvania, Kentucky, Texas, where I'm located, as well as South Dakota. Does someone have to do their planning in South Dakota? No, they don't have to do their planning in South Dakota. But I love talking about these issues because clients who are high net worth clients, and that can be loosely defined, they have certain things that are very important to them, and that is privacy, that is asset protection, and that is control or flexibility, right? Control and flexibility. And estate planning attorneys need to be having these conversations with their clients when they're walking through this process, because maybe it makes sense for you to do your planning in Texas if you're a Texas resident, but maybe depending on your situation, your family situation, your financial situation, it makes sense to go to South Dakota. Or maybe you're in Florida, maybe it makes sense to go to South Dakota. It doesn't matter where you're located. There should be this conversation around what your goals are and what's most important to you. And we also need to be looking down the road and considering what obstacles or risks could pop up if the worst happens. And this is a prime example of when the worst has happened.